Joyce, I wanted to ask you, Jonathan Mitchell, who represented Donald Trump for those oral arguments before SCOTUS, he clearly dropped the presidential immunity argument smack dab in the midst of those arguments on Thursday. Your thoughts about the fact that he might be previewing it because Kavanaugh was nodding his head along the way when the presidential immunity thing was said. Do you have a concern, Joyce, that SCOTUS, hasn't officially been asked necessarily to take it up yet at this point, but that decision is going to be made imminently?
So I'm going to play appellate lawyer here and say I resist this temptation to conflate the two cases, at least substantively. They have nothing to do with each other. They will be treated like separate cases by the justices. But of course, Katie, we all live in the real world, and we appreciate that there is some interplay. Just how much of a tolerance does this court have for cases involving Donald Trump in election year? We know this Supreme Court, really all Supreme Courts, but this one in particular, doesn't want to be in the position of deciding elections. They don't even like to decide political questions. So I think that there's a possibility that although Trump's lawyer was quick to preview the case, the Supreme Court may simply affirm the Court of Appeals when the immunity case comes in front of them.
So, Andrew, to Joyce's point, Kavanaugh is the one who teed up the issue of 2383, the Insurrection Act, when he asked Jonathan Mitchell, again, Trump's lawyer, basically, well, Trump wasn't charged with that particular crime, which would have been a slam dunk when it came to disqualification. In your opinion, Andrew, should that crime have been charged?
You know, I think there were two good reasons not to do it. One better than the other. One reason that could have come to play is that that is a crime that is typically not charged. And when I say that, that is an understatement. You know, you'd have to go back scores and scores and scores of years, and it would have opened up the department to the idea of selective prosecution, if not legally, at least in the court of public opinion, of why are you charging this? And the answer would have been, well, we've never had a former president engage in conduct like this. I think the second, though, is almost precisely Kavanaugh's point, which is that they didn't want to politicize this prosecution. And if they had brought a charge where the remedy in the statute for a conviction is disqualification from running, then Donald Trump would have said, look, you are in fact doing this for political purposes. You are doing it to get me off of the ballot, so I cannot run. And so by avoiding that particular charge, they were trying to sort of depoliticize this to say, no, what we're doing is we thought you committed a crime. We think that the jury should be presented with that evidence, and we'll see whether they agree with us. And so the issue of the remedy, it was not why the case was brought. And I think that's a pretty powerful argument for doing it as to why they did not bring this charge. Again, this is just speculation on my part, but I think those are likely to be the two things that they were thinking about.
But George, during these arguments, the lawyer for the Colorado voters, Jason Murray, said the following: there's a reason Section 3 has been dormant for 150 years, and it's because we haven't seen anything like January 6th since Reconstruction. Insurrection against the Constitution is something extraordinary. You know, George, to what Andrew just said, nobody made Donald Trump crime. Nobody made Donald Trump break the law. And if the consequence of breaking the law was disqualification from the ballot, then so be it. So why is it that if there's some almost like kind of consideration of what the court of public opinion might perceive what the DOJ is doing, then but everybody knows that everybody thinks this is a political prosecution anyway on the side of the Republicans, why not actually go for the jugular and get as much as you can against somebody like Donald Trump if it meets probable cause?
Well, I in this particular case, because they want a conviction, and when you are charging things, I assume it's the same. I'm not a criminal lawyer. I didn't prosecute, but I wrote complaints in the civil realm. You don't always put everything you can possibly bring. You want to focus on the claims that are easier, that will get you the result that you want. And the conspiracy to defraud the United States, I think, is a no-brainer. I think the charge of obstruction is obstruction of an official proceeding is a no-brainer. And I see every reason for them just to go with those which are tried and true and have been working in these January 6 cases, then go try to have to figure out how he connected to every single person who was out there on Capitol Hill that day, beyond a reasonable doubt.
Joyce, I got about 30 seconds. Ladies last, and you definitely are a lady. Joyce, I want to ask you about states' rights. What happened to states' rights on Thursday? Because they didn't seem to exist during the back and forth questioning that happened between all counsel and members of the highest court of our land.
Right. States' rights disappeared, and this notion that we should have a limited federal government and that states should make the bulk of decisions was seemingly absent. And look, Katie, I don't want to overplay that hand. This is a question that has national dimensions because we're talking about electing national candidates. This court may well rule that one state can't make decisions about candidates' eligibility for the entirety of the country. But states' rights, a notable feature in Dobbs v. abortion case, where the court decided to let every state make up its own mind, was not present in the courtroom this week.